Hello, and welcome to the Ministry of Government Relations four-part webinar series on development appeals. This series provides important information on development appeals processes and procedures. This video is part 4 in the series and provides information for making a decision on a development appeal. The content of this webinar series is based on the Development Appeals Board guide on Saskatchewan.ca. This guide includes several samples, checklists, and flowcharts to help make the Development Appeals Board process as simple as possible. To access the guide, search Development Appeals Board Guide on Saskatchewan.ca. In this webinar, we will examine the legislated considerations for making a decision on an appeal, the options available to the board in making a decision, the procedure for making a decision, and the right of appeal on the board's decision. In making a decision on a development appeal, the board is bound by the requirements of legislation. Section 221 of the Act lays out the requirements that the board's decision must adhere to. In hearing an appeal, the board is bound by the policies in any official community plan in effect at the time. The board does not have jurisdiction to vary or overwrite the requirements of the official community plan. They must ensure that its decision conforms to the use of land, intensity of use, and density of a development in the zoning bylaw. The board does not have jurisdiction over land use matters, including the intensity or density of development. For example, the board cannot approve a development where the land use is not permitted in that zoning district. Therefore, board decisions must be consistent with land use restrictions in the district. Finally, they must ensure that its decisions are consistent with provincial land use policies and statements of provincial interest. The board's decisions must not contravene the statements of provincial interest or any other legislated requirements. The Statements of Provincial Interest Regulations are regulations of the Act that address 16 objective-based policy areas for which municipalities and the province have a mutual interest. In recognizing the impact that appeal decisions may have on province-wide interests, decisions of local development appeals boards are required to conform to these regulations. For example, Statement 6.7, Public Safety, requires the prohibition of new development within the floodway of a 1 in 500 year flood elevation of any watercourse or water body. This means that an appeal board must not issue a decision permitting development in these areas, since it would contravene this statement. In making a decision on an appeal, the board must also consider 3 tests or bars of entitlement to granting any variance of the bylaw. The proposed action must not 1. Grant the applicant a special privilege, which is inconsistent with the restrictions on the neighboring properties in the same zoning district. The Saskatchewan Municipal Board typically refers to a 1987 appeal decision when defining whether an action constitutes a special privilege. The decision asks, would the board grant the same privilege to another property owner subject to the same bylaw restrictions where the same need and conditions exist? The key to answering this question is identifying the special circumstance that makes complying with the bylaw provisions difficult or unnecessary. The second test states that the action must not amount to a relaxation so as to defeat the intent of the zoning bylaw. Section 45 of the Act outlines the general purpose of zoning bylaws, which is to control the use of land for providing amenity for the health, safety, and general welfare of residents. In addition to the general purpose of the zoning bylaw, it may also be beneficial to consider the purpose of the specific development standard under consideration. For example, side yard setback requirements are typically intended to provide access to rear yards and amenity space between buildings. They are also often linked with building code standards. Therefore, any variance of this setback may have consequences for other bylaws. Generally, it may be acceptable to vary a standard if the objectives and intent of the standard can still be met. The third test states that the action must not injuriously affect neighboring properties. To consider this test, the board typically considers any comments submitted to it by the neighboring property owners. The Act requires that owners within 75 meters of the property be notified of the appeal and be given the opportunity to comment. It is through this notification process that the board may be able to determine whether the proposal will injuriously affect neighboring properties. For example, a reduction in the side yard setback may result in the adjacent building no longer meeting building code requirements, since some construction requirements are measured from building to building, rather than from the property line. In that case, it would be injurious to that neighboring property to reduce the setback. The severity of implications to other bylaws and standards must always be considered when addressing the 3 tests. The board has been granted the authority under Section 221D of the Act to confirm, revoke, or vary any approval, decision, development standard, or condition, or order imposed by the council or development officer. They may also make or substitute any approval, decision, or condition that is considered advisable within the parameters of legislation. The board is required to issue its decision in writing within 30 days of the conclusion of the hearing. The written decision must be sent by personal service or registered mail to the appellant, the municipality, the director of community planning, and all persons who made representations at the hearing within 10 days of the date of the decision. If the appeal is approved, the approval is valid for the period of time that the development permit is valid. The approval lapses upon the expiry of the development permit, typically 6 months. The municipality may renew the development permit or issue another development permit in accordance with the board's decision. The decision is specific to the proposed development as outlined in the materials and plans submitted to the board. The decision takes effect 30 days after the date it is made. Once the board has made a decision regarding the appeal, it must prepare a written summary of the decision, including arguments, materials, and presentations according to the appellant, arguments, materials, and presentations according to the respondent, and the facts and considerations that the board deems relevant to the appeal. Once complete, the secretary is responsible for reviewing the decision and making any minor revisions as necessary. The written decision is once more approved by the board and signed by the chairperson and secretary. The written decision for the appeal should include information on the right to further appeal. Every decision of a local development appeals board may be further appealed to the Saskatchewan Municipal Board within 30 days. Upon receiving the notice of appeal from the Saskatchewan Municipal Board, the Development Appeals Board Secretary shall provide all records, including the notice of appeal to the local board, all materials filed with the board prior to the hearing, evidence provided at the hearing, minutes of the hearing, and a copy of the written decision. All decisions of local development appeals board may be appealed to the provincial Saskatchewan Municipal Board by an affected person, applicant, council, or neighboring property owner. The Saskatchewan Municipal Board does not rehear the matter that was before the Development Appeals Board. Rather, it reviews the original decision for errors of law based on the evidence, documents, and arguments made at the original hearing. The Saskatchewan Municipal Board typically does not accept new evidence, since it is reviewing the original information available to the Development Appeals Board. The Saskatchewan Municipal Board may accept new evidence if the original record is incomplete, unclear, or does not exist, the board omitted, neglected, or refused to hear or decide an appeal, and relevant information has emerged which was not available at the time of the hearing. If the Saskatchewan Municipal Board finds that the Development Appeals Board erred in its decision, it must then do what the original board ought to have done, which may include overturning the decision. Decisions of the Saskatchewan Municipal Board may be appealed to the Court of Appeal within 30 days of the decision. Any affected person, like the applicant, municipality, neighboring property owner, may apply for leave to appeal the decision. A judge will determine whether the appeal has merit. If it does, it will be allowed to proceed to the Court of Appeal. If it does not, the matter is ended. Court of Appeal decisions are final. There is no definition in the Act for who constitutes an affected person. Typically, it is left to the board or the courts to make that determination whether the person appealing is truly affected by the proposal. This concludes our final webinar in the Development Appeals series. To revisit the other steps in this process, look for the videos listed on screen. If you have any questions related to the Development Appeals process, please contact the Community Planning Branch for assistance. The branch also offers in-person development appeal workshops that explore this content in more detail. Please contact the branch to arrange for a workshop in your area. Thanks for watching.